Heavenly Father, may we take a moment to reflect on the people who have served our nation and to all those who are doing so now, today. Bless them who so unselfishly sacrifice their time and their lives so that we may enjoy freedom. We ask that you continue to keep this nation under your care and provide a clear vision for your will to our leaders. Guide this board in the decisions before us today. Amen. Supervisor Mohave.
Please join me in the pledge.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Do we have anyone signed up for call to the public? Okay, let the record reflect that there has been no one requesting a call to the public. First item on the agenda is Annie Newton-Fruworth, the procurement manager, to ratify emergency procurement number 13-EP-03, hot mix asphalt to Cemex, Bullhead City, Arizona, for road repairs to portions of the Davis Dam Highway, State Route 68 to Catherine Spur Road, and sections of residential roads in Golden Shores for the amount of $106,128.75 in accordance with the Mohave County Procurement Code, Article 3, Section 8, on behalf of the Public Works Department. Is there a change? I understand there may be a change in that number. Is that correct?
Good morning.
And good morning.
Annie's not able to be here today, so I'm going to speak on this item. There is a change. I believe you all got a memo. If you didn't, I made extra copies. And if there's questions about how we arrived at the new number, Steve Latosky from Public Works is prepared to speak. But initially, we approved an emergency for both Davis Dam and for portions of Golden Shore residential area. And then after the roads department went out and started beginning work, I believe, on Davis Dam, they determined that hot mix was not the best method. And so we're requesting a revised motion to ratify the emergency procurement for hot mix asphalt to CEMEX, and it's just a revised amount in the amount of $35,376.25. That's reducing the purchase from 1,500 tons to 500 tons. Any questions?
Any questions? I have none, and thank you very much for
Did you
your
guys
report.
get the memo? Do you need a copy of it? You did? Okay.
Actually, we all received a copy of that memo. Thank you.
Yep.
I'll make a motion to approve.
Second.
I have a motion and a second to approve item number 1, ratify the emergency procedure for the hot mix asphalt to Cemex. Questions? There being no further questions, those in favor signify by saying aye.
Aye.
Those opposed, motion carried. Item number 2, discussion, possible action, approve the scheduling of an additional board meeting of the supervisors, an additional one per month for the calendar year of 2013. I brought this item for discussion, so I'll move for discussion.
Second.
A motion and discussion. Those in favor signify by saying aye.
Aye.
Those opposed? And the reason I brought it forth is obviously if we're going to continue to have extremely long meetings like we've experienced the last several months, it may behoove us to go ahead and schedule back to 2 meetings a month. And bringing you today for your thoughts and considerations.
May I, Mr. Chairman? I think it's a wonderful idea, and I'm embarrassed that I did not suggest it first.
Supervisor
Mr. Chairman?
Yes.
Supervisor Johnson.
Just to let everybody know, we've had this in the past where we've had two meetings. The problem that comes up is we finish a meeting on Monday. By that Thursday, you have to have backup in for the next meeting. That means that basically your staff has to be continually doing agendas and doing research for our meetings. The one a month has, at least in my opinion, I believe, made a better use of our employee time, and I think it's up to us to control the meeting length time, and if they take all day, they take all day. But I think two of them puts a lot of undue pressure on staff just to do meeting agendas. That's all.
A good point. Supervisor Johnson, Supervisor Brotherton.
Well, if we have it like the first Monday and the third Monday, then you wouldn't have to have the backup material in that soon, would you?
Yes.
That end of that week.
The only other thought I had was if we didn't go to 2 meetings per month is, we could always call a special meeting such as the one we're having today. And it's my hope that the long meetings, the ones we experienced over the last several months, we've gone through many numbers of different thoughts, agenda items, and even reorganization. So I'm open for discussion. I can do one a month with possibly a special meeting occasionally, which might make more sense.
May I, Mr. Chairman?
Supervisor Moss.
It might be a good idea to ask the clerk and the county administrator, is going to 2 meetings a month, is it going to put undue burden on staff?
Mr. Hendricks?
Obviously, Mr. Chairman, Supervisor Moss, we can accommodate whatever the board wishes, but Supervisor Johnson does make a good point. If we go to 2 meetings, the staff is constantly preparing for a board meeting, and that does take up a considerable amount of time if we continued with the 1 meeting a month. And with the special meeting, as Supervisor Watson suggested, I think that would probably allow staff to be more efficient and effective.
Well, I brought the item to the agenda, so I guess the way it might function the most efficient way would be to continue with 1 a month, and then from time to time, if we do need a special meeting, all it takes is 5 days to call that meeting. So,
Let me ask it another way, if I could, Mr. Chairman.
Supervisor Moss?
A lot of times we have, in fact, frequently, we've had agenda items that are in excess of 100, it seems like recently anyway. And is there any prohibition for certain of those items being pushed back? You prepare one agenda, but you then break it into 2 to be covered by 2 different meetings. Because I've noticed that the public participation falls off in the afternoon time in our regular meeting, because people have the morning off, they can get a couple hours, but they can't get 6, 7, 8 hours off. Mm-hmm. So what's the difference between preparing one lengthy agenda and breaking it in 2 and having 2 regular meetings? Or is that not, for whatever reason, a practical solution to the problem?
Mr. Hendricks or Mr. Ekstrom, do you have a thought?
Mr. Chairman?
Supervisor Johnson?
I'll jump in on that. I think sometimes we do have a lot of items on the agenda, but most of them are usually on the consent, which is, should be routine business, which any supervisor can pull off if they so desire. I think the problems come more from the ones that are put on for discussion that are linked from supervisors that bring up that make the meetings go longer. That was just my opinion, Supervisor Moss.
Thank you, Supervisor Johnson.
And Mr. Chairman, just to build on what Supervisor Johnson said, I believe staff could recognize items that would take a special board meeting. Let's say a good example would be the selection of the county administrator. When that comes up, that could be a special board meeting to where there would be, you would anticipate considerable discussion and considerable attention that the board would have to grant to that particular item, and possibly we could identify those instances, and then schedule the special board meeting to take those particular items.
Thank you.
Can I say something?
Certainly. Supervisor Anga?
Another thing one of the reasons also for board meetings, besides just doing the consent agendas and the business, is for the public to come and speak. We went through this at the Bullhead City Council, because they have 2 meetings a month, and sometimes there's not a lot on it, and there was discussion about changing that. But again, it's about the public. It gives the public another opportunity to come and speak. Maybe they can't come on the first Monday, or Mondays aren't good. There were some suggestions. Maybe we would do the second one in the afternoon, and that would be more why I would want to do it, to give people more of an opportunity. Like Supervisor Moss said, that if these run long, some of if the ones that people want to speak to at the end, they tend not to stick around. We saw that in some of the people who had signed up, but they weren't there by the time we talked about it. So, I would say give it a try and see how it goes. I don't really see, like Supervisor Moss said, it's being that much more time for staff, because you're still doing the whole thing. You're just kind of having it, and then we can always know that we have another meeting, so we could say, well, we'll talk about this, we'll table it till the next meeting. We don't have to wait another month. That's my opinion.
Thank you, Supervisor Anga. The only thing that does block this is the constant preparation for that next meeting, and the cutoff being so short. Actually, it's only 4 days. And I guess at this point, because we have the ability to call a special meeting, and I think I'm feeling more comfortable with the ability to call a special meetings. Maybe if all of us feel comfortable with that, knowing that there might be more special meetings, that it might alleviate, instead of going through the entire calendar now and trying to make it all fit. Would you folks be willing to consider trying the special meetings as an alleviation to the problem that we've had?
If I may, Supervisor Watson,
Supervisor
Mr.
Mott.
Chairman. The benefit, what I think your suggestion would take care of the congestion within the agenda. But the benefit of a regular meeting is that the public would always know that there's the first and third Monday of every month, there's a meeting. And so they don't have to worry about tracking whether or not there's a special meeting, which is published on, a few days' notice, as opposed to just knowing that on Monday morning or Monday afternoon or whenever the time is of a second meeting, just to show up. So I think your suggestion would take care of the congestion, but I don't think it would necessarily keep the public 100% informed as to our scheduled activities in this room.
I see your point. Well, I'll entertain a motion.
I move that we go to 2 regular meetings a month on Mondays, the first and third Monday of each month.
I second the motion.
Any further discussion? There being no further discussion, those in favor signify by saying aye.
Aye.
And those opposed,
Nay.
motion carried. Item number 3, Supervisor Angus.
I move to discuss.
Second.
We have a motion and a second for discussion. Those in favor signify by saying aye.
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 Those opposed, motion carried.
Okay, the reason for this special meeting we called was, this was continuing from our discussion from the last week, when we approved a special investigation, and what I've been doing this week was sort of trying to figure out who the best team for this investigation would be. Staff had provided, and thank you very much, lists of private investigators and just anyone that would be appropriate to do this. But I was also thinking about something that Supervisor Johnson brought up when he voted against it, saying that it was about the cost of it and who's going to bear the cost of it, and not really knowing how long and how deep this is going to go. I just thought maybe it would be better to do this in-house if possible, if there were the right people. And I believe the right people have come forward. And I've met with some County Investigator Terry Flanagan. I work through County Attorney Matt Smith. Thank you very much for all the cooperation from your office. And Mr. Flanagan has expressed an interest in doing this type of investigation, and then brought up a gentleman named James Shopman, who's a lawyer with the county attorney now, but I believe he's going over to the sheriff's office. And I got permission from Tom Sheehan, Sheriff Sheehan, and again, Matt Smith, to allow these two to work together on this special investigation, but report directly to the board. So I have a motion, but I assume people want to talk to this.
Mr. Chairman?
Supervisor Johnson?
Supervisor Angus,
Angus.
did they give any idea of a time length?
Investigator Flanagan is actually, and you might remember him because we gave him an award last week for his 35 years. He's actually retiring in August, and I believe that would be sort of our time frame. I hope this doesn't go. I don't foresee it going as long after that, to that, or even after that. But it will be what it is. I'm not going to put a time length on it. It's going to take us where it takes us. But like I said, he is going to be retiring in August, and I felt comfortable enough to still want to work with him knowing that.
Sounds good, thank you.
I put a little bit of input. My concern was how much it was going to cost. And so with the use of Mr. Flanagan and Mr. Shopman, I feel much more relieved that those costs will be entertained much more efficiently than by outside counsel or investigator, so I feel comfortable.
There's one more thing, and also we still have the FBI who said they will work with us and do some of the auditing and accounting that would have cost us a significant amount of money as well. So that would be the team.
I would like to ask County Attorney Matt Smith. Matt, would there be a possibility that this could cost us an unforeseen cost hidden in this, possibly?
Supervisor Watson, Chairman Watson, actually, and the rest of the board, Mr. Extra, Mr. Hendricks, I've had a chance to talk to not only Supervisor Angus, but also James Shopman and Terry Flanagan. They both have indicated that they would be interested in doing this investigation. The hidden costs would be what happens when Terry Flanagan retires. So we're talking about a few months down the road. July, August is when he's talking about. I think he's leaning towards August. There's a chance that he would stay a little bit longer, but there's also a possibility that he retires, this case is still going on, and then at that point, I think that there might be an issue of he would have to be paid. Again, you have no idea how long this investigation is going to take or how complicated it's going to be. From my personal viewpoint, I certainly would want to be able to replace Terry Flanagan when he leaves and not be bound to the fact that, well, since he's taking on this other position, he's now working as a contract employee for the board, am I going to be able to replace him? So that's the only personal concern I have. But I think there's also a possibility the investigation would be wrapped up for the most part. I also think there's a possibility Terry Flanagan might stay longer if he's getting close to completing the investigation. James Shopman has been recruited, poached, if you will, by our sheriff from our office, and is going to be starting there, I believe, July 1st. James said he's interested in doing it. I know that Supervisor Angus has already talked to Sheriff Sheehan, and Tom has indicated that he would be willing to allow James to continue to work on the case. So the only issue there would be if it became, for some reason, a criminal matter, then of course it would be back to our office. And I talked to James and he said, well, I don't know, would I still be allowed to prosecute it? And I said, well, we would give you special permission to be able to still do that. So I can't imagine that James would cost the county any money. So you're probably talking about a minimal cost for Terry Flanagan if he retires August 1st and is continuing to work on it.
Okay.
All right?
Clarifies my questions,
Mr. Chairman, may I?
certainly.
Hi, Matt. Thank you. So well, basically, these issues you raised are more akin to the items where there may be identification of potential future issues which we'll have to resolve if and when we come to them.
Yes.
Okay. Thank you, Matt.
Any further questions?
Mr. Chairman, board members, on a collateral issue, there are some elements of this investigation which I feel compelled to discuss with the board in executive session, and would ask, I believe at the chairman's request, that we hold an executive session on those issues after this meeting, and suspend doing that until the meeting's completed, then we'll have a meeting to discuss these issues.
Okay.
Do we need a motion on that, or?
Let's,
We'll need a motion to convene an executive session for legal counsel after
at the
item
end of the
7.
meeting.
Okay.
What we do require now is a motion for this item.
Thank you, Matt. Okay, I move to appoint County Investigator Terry Flanagan as lead investigator and James Shopman as legal counsel to work with and independent of the FBI to investigate the mishandling of Lincoln Financial voluntary insurance payroll deductions and all other insurance and benefit issues brought to the attention of investigators and approved by the Board of Supervisors during the course of the investigation, and require all Mohave County employees comply with requests from the investigative team. This team will report to and take instructions solely by the Board of Supervisors on matters of this investigation only.
Second?
We have a motion and a second. Any further discussion? There being no further discussion, those in favor signify by saying aye.
Aye.
Those opposed? Motion carried. Can we hand that down to our clerk, please? You have it. Thank you. Okay. Item number 4, discussion, possible action, reconsideration of item 97, item B regarding removal of weapons, prohibition of staff employees as voted on the April 1, 2013 Board of Supervisors meeting. Supervisor Johnson, this is your item.
Mr. Chairman, I'd make a motion for the reconsideration of item 97, item B, from the April 1st, 2013 board meeting.
We have a motion
Second?
and a second for discussion. If you'd like to go ahead, Supervisor Johnson.
I believe we just need to reconsider it, and then I'll go to the next one if we take a vote.
To clarify, is the suggestion that we reinstate the prohibition for employees to carry weapons in the building?
Mr. Chairman,
Supervisor?
Mr. Chairman, Supervisor Moss, on the reconsideration, I just need to get a reconsideration, then I'll null and void it, what we did last time, and then we'll go to item number 5, which will be the item we had on last time.
So we have to get rid of the last one before we can go to the last one? Okay, so I'll second that motion.
Okay, we have a motion and a second for the reconsideration. Those in favor signify by saying aye.
Aye.
Those opposed?
No.
Motion carried. Item number 5.
Mr. Chairman,
Supervisor Johnson.
I'd make a motion for discussion.
Motion for discussion
Second.
and a second. Those in favor signify by saying aye.
Aye.
Mr. Chairman,
Supervisor Johnson.
to answer Supervisor Moss's question, brought this back because we had a lengthy discussion last time on this item, and I believe we had decided that for legalities, it was best just to remove the wording in our merit rules, did away with weapons being prohibited, and just leave it at the discretion of the employee. We neither said, yes, you can carry weapons, we neither said, no, you cannot carry a weapon. And that would be in all buildings. I think that's what the discussion was, and that's why I brought it back.
The motion that I presented was limited to this
That's
county
what?
administration building.
Right, and I thought that we were voting on all buildings, and that's why I brought it back, Supervisor Moss.
Thank you. Mr. Chairman, may I?
Supervisor Moss.
The reason why I limited to this county administration building was really a twofold reason. First, I don't think we have the ability to tell the courts, which includes probation, or the sheriff's department, or the county attorney's office, all of whom are representatives of other branches of the government, what to do in their portion, their share of the county buildings when it comes to internal security. The second is, it was my intention to request that staff provide a list, because there's many, many county buildings out there, some of which are accessible to the public, some of which are not, some of which would be not a good idea for security reasons, some of which it would be a good idea for security reasons. I'm very much interested in expanding the scope of the employees for carrying weapons, but I thought there might be a period of time in which we could evaluate and investigate the scope of employees carrying weapons in other county buildings.
Mr. Chairman?
Supervisor Johnson?
Mr. Chairman, Supervisor Moss, I believe we took the weapons ban away for citizens, and I believe the same thing should apply to the employees, and the restrictions would be put on, and Attorney Ekstrom can get involved if he likes, where the courts have the ability to say they do not allow weapons as to other facilities as the Sheriff's Department.
May I, Mr. Chairman, for just one moment?
Supervisor Moss?
The employees' weapons ban or lack of prohibition was also limited to this building. It was not county-wide on every county building. So both the public and the employees under the revised or the prior motions were limited to only this building.
Supervisor Angus?
That's not what I understand. Can you verify that for us? I understood that the public prohibition was for all buildings, not just this building.
Mr. Hendricks?
Mr. Chairman, Supervisor Angus, I'd like to try to make a quick clarification on this particular item. We may have to do some research on your question, but the way I understand it, if we remove any reference to prohibiting employees from carrying guns in county facilities and state law takes over, and if a building such as the courthouse or our libraries are properly posted and have the ability to handle the storage of guns, then that prohibition, that posting of that facility would apply to employees and to citizens alike. So that's my understanding, at least. Regarding your question on whether it was the prohibition was specific to this building, that was my understanding, but I would like to be able to verify that so that we can be completely accurate to you all.
Thank you, Mr. Hendricks.
And I believe Supervisor Johnson had a question for Mr. Ekstrom, because I was just using my high school civics class when I came to the conclusion that we can't tell the courts and the sheriff and the county attorney what to do inside their building, because the courts are obviously the co-equal judicial branch, and the county attorney and the sheriff are representatives of a portion of the executive branch's power. But maybe we should probably rely on someone who would know more than my high school civics level issue on that, as to whether we can tell them to allow or not allow weapons in their buildings.
Mr. Chairman, Mr. Moss, the county has a responsibility to provide buildings for elected officials. The extent to which we control those buildings, I think, is up to the individual elected officials. And I know as county attorney, I had a no weapons policy in my office, and people picketed, and I had to deal with the issue, but I always believed that it was my call, what happens in my office. Clearly, the courts are in that situation. They have a separate security system. I think what Supervisor Johnson is talking about is, and I'm sure I'll be corrected if I'm not correct, is all the other county offices, public works, and places that are not domains of elected officials should be treated the same as this building. That was his point. And I remember the example of the Parks Department and the lady that works up at the top of the Wallapai. She's by herself with a box of money, and can't defend herself. So that was my understanding of it, which probably doesn't go far beyond basic high school civics.
Right. Mr. Chairman, may I?
Supervisor Moss.
I personally, I mean, I very much approve of expanding county employees to carry everywhere that they're not prohibited by other elected officials who represent a co-equal branch of government, such as county attorney, the sheriffs, the courts, which would be inclusive probation. And if that is the tenor of the board, I'm excited. I was going for a much narrower, more limited prize for the employees, attempting to craft what I thought would form a consensus. But if the consensus is more, I'm 100% on board of that and would like that. So with that said, if I may make a motion, Mr. Johnson, or Mr. Watson, I would like to do so, if you would allow me to do that.
Supervisor Johnson.
Sure.
Supervisor Moss would like to make a motion.
That's fine with me.
All right.
I move that we eliminate any prohibition for county employees from carrying weapons while in the employment of Mohave County, Arizona, excepting only the courts, inclusive probation, the Mohave County Sheriff's Office, the Mohave County Attorney's Office, and other offices of independent elected officials which may arise on a case-by-case basis and be brought to our attention.
I'll second.
I have a question.
Motion and a second. Question, Supervisor Johnson?
Yes, Mr. Chairman, Supervisor Moss, and I guess probably the Attorney Ekstrom could get in this. Would it be better with your motion just to say that we have no say one way or the other? We just remove from the merit rules of we don't say you can carry a weapon, we don't say you can't carry a weapon, and we leave it up to the elected officials in their departments, because we're kind of telling them again, saying, no, you can't carry weapons in those departments. Leave it up to the judges, the sheriff, the attorney, the rest of them to make their own decisions.
Mr. Johnson, that was actually my intent, and if I stated the words poorly, I apologize. So if I may amend and restate my motion, I'll make another effort at it.
Okay, well, we have a motion for amended motion. We need a motion for amended second.
I second.
Okay, amended second. Okay,
Amended.
you'll proceed.
Okay.
I move that we remove the prohibitions from the county merit rules and other personnel rules which prohibit employees from carrying weapons into county buildings, excepting only leaving such a prohibition to the independent judgment of other elected officials, such as the courts, inclusive of probation, the Mohave County Attorney's Office, the Sheriff's Department, and other coextensive elected officials.
Second.
We have a motion and a second, and clerk is satisfied with the motion? Okay. Any further discussion? There being no further discussion, those in favor signify by saying aye.
Aye.
Those opposed? Motion carried. Item number 6, discussion, possible action, authorize the Public Works Director to approve an application for special event permit within Mohave County right-of-way, Dolan Springs, with the assembly on the Tom White and Spur, then traveling south on Pierce Ferry Road to Lloyd for an annual parade event to be held on May 4th, 2013, upon applicant's fulfillment of Mohave County Public Works Department special events permit policy requirements. Supervisor Brotherton.
Yes, Dolan Springs has their annual parade every year about this time. There was some question as to whether or not they were going to have it this year. Then they decided they were going to, so they had to scramble. They didn't get it in for our last meeting. I think they've submitted everything to our planning and zoning, everything that is needed. I think the insurance and everything is in place. So they do want to proceed with having their annual parade, I think May 4th of this year. So I make a motion that we approve item number 6, approve the application for Dolan Springs to have their annual parade.
Second.
I have a motion and a second.
Mr. Chairman,
Supervisor Johnson.
and with Supervisor Brotherton's motion, that includes the fact they get all their paperwork in by Public Works.
Yes, they have all their
Yeah.
paperwork in.
All right, thank you.
Thank you. There being no further questions, those in favor signify by saying aye.
Aye.
Those opposed, motion carried. Item number 7, discussion, possible action regarding the status of drafting, distributing, and gathering completed conflict of interest forms from county employees. This item is continued, the board at their April 1, 2013 meeting. Supervisor Moss.
I reviewed the materials provided by staff. Thank you very much. I liked what I saw. I did have one question, if I could. Number 2, which references this does not apply if one of the parties are, one of the contracting parties is a landlord or tenant. I really didn't understand what was attempted to be said there on that particular line.
Mr. Hendricks?
Mr. Chairman, Supervisor Moss, if it pleases the board, I'd like to have Ray Osuna come up and address that.
Certainly. Mr. Osuna?
Good morning, Mr. Chairman, Board of Supervisors. Let me refer to that area. Was that number 2, Mr. Moss?
Number 2, on the guidelines that you had provided, which, by the way, other than those 2 questions I have, and that's one, was very well done.
Thank you. I beg your indulgence, I can't find it.
I believe it's at the top of page 2 and 3. It gives you a numeric list of examples as to which this would not apply.
I found it, just a minute. I see which article or sentence you're looking to, Mr. Moss. You're talking about a remote interest not applying to an employee or employee's relative is a landlord or a tenant of a contracted policy. My interpretation of that is just that it doesn't apply to landlord situations as it does to substantial financial interest. I think it's permissible, even though remote, that this not apply to a landlord or tenant as a contracted party.
So if I may ask a question and follow up then, Mr. Chairman?
Certainly, Mr. Moss.
If my wife owned a building and rented it to the county, I would not have to disclose that.
That's correct, Mr. Moss.
Okay. I have a second follow-up question, if I could. I forget the number, and I read it, and I apologize, but there's a reference to 3% interest in a corporation below that. Do you see that?
Yes, I do.
What if I have, hypothetically, I come from one of these big, large families where you have 23 siblings, and by the way, don't laugh, my wife's father is one of 23 siblings, and then you have all their spouses, and they all each own 3% of a construction company. Would that have to be disclosed?
In my opinion, Mr. Moss, no.
Even though in aggregate, my family would own essentially 2/3 of that company under the hypothetical
Yes,
I gave you.
Yes, sir. In my opinion, that would not be in the aggregate.
Okay, so
Supervisor.
this employer-employee's relative is a landlord, so you're saying that wouldn't have to be disclosed?
If my wife rented land in Mohave County, Arizona, it would not have to be disclosed.
Well, I
because
think
this
it
was
has to.
I think it does, but the guidelines we're proposing, or have been
Right.
presented to us for proposal, would mean that those transactions, my brother owning a building, my son owning a building, my wife owning a building, which rented to the county, would not have to be disclosed as a conflict because it's allegedly de minimis.
Allegedly a what?
Well, those numeric numbers are examples of what we as a county would, if we approve it,
Right.
consider to be de minimis transactions, which means it's not really that important
Oh,
to
well.
influence anybody.
Well,
I
believe-
disagree.
Yeah, all
I
right,
just-
I know, I
but-
know you are, but you didn't
but-
say it yet.
but
Yeah,
those
well,
are-
I disagree with that, so I would like that changed within the context, because I believe that is a, that's a big one. And it's actually addressed in the statute itself. Because I know here in this county, leases do not go out for bid, but according to the statute, if it is a lease and there is a conflict, it must go out for bid. So I'll not vote yes on anything that doesn't address that.
If I could, Mr. Chairman,
Supervisor Moss?
what number is that 3% rule that we just talked about a moment again on the numeric list of what's allegedly considered de minimis?
Mr. Chairman, Mr. Moss, that is number 5 on page 3.
Mr. Chairman,
Supervisor Moss?
it occurs to me that since I've detected 2 problems that I don't necessarily agree with, and that was just on my reading over the weekend while sitting at the soccer field cheering on a bunch of 10-year-old girls, that maybe a closer reading of this proposed policy would be appropriate, and that this should be tabled to our next regular meeting so I can come with so staff could, one, have the opportunity to explain what I consider to be these 2 discrepancies, but also so that the board would have the ability to scrutinize this new policy, including the de minimis examples which are listed in a little more detail, and make a more fully informed decision come our first meeting in, I believe, would be May.
I think that makes a lot of sense, Supervisor Moss. In the spirit of conflict of interest, it's my belief and feeling that it's any and all. And I think that's the direction that we ought to proceed in. So tabling the motion, I think, would be a very good idea.
And having said that, Mr. Chairman, I do like the form that was presented. I mean, I do like that. So I give you guys kudos for that. So,
So in your motion,
Chairman.
if you'll...
I have a
direct that.
comment, Mr.
Supervisor
Chairman.
Brotherton?
I know, last meeting, I recused myself from voting on an issue because I had a relationship with one of the companies. Now, I may be mistaken, but I was reading the statute, and actually, my relationship wasn't listed as a relationship.
that's why at the last meeting I said that you went overboard because, even in my opinion, you don't have any obligation to recuse yourself.
Well, I'd rather go overboard than be amiss. So anyway, I guess I need to read the statute again and see, because it actually does list the relatives, but they definitely list husband and wife.
Husband, wife,
Yeah.
parent, child, brother, sister.
So,
Well,
okay.
again, I guess I'll reiterate my thoughts. But
Susie.
it is truly in the conflict of interest. It's any and all in my feeling. And it's for the benefit of the constituents to know of any practical matter of any course of business. So in the spirit of conflict of interest, it's very simple, any and all. But if you're going to table the item, you might want to give some direction.
Yes. I move that we
We
table
have
item.
Supervisor, I'm sorry. Susie Duranzo?
Mr. Chairman, Mr. Moss, Susie just brought to my attention in terms of her responsibility some landlord information.
Supervisor Watson, Chairman Watson, and members of the board, I'd like to address the issue of conflict of interest as it relates to the Board of Supervisor sitting as Mohave County Housing Authority. This is something that's probably I need to bring out to your attention. Years ago, the Board of Supervisor passed actually a conflict of interest policy for the Board of Supervisor that it is a conflict if the members of the board and their families would rent a unit for housing assistance under Mohave County Housing Authority. So in the case of the question that Mr. Moss has raised, say for instance, your wife or your husband, for the other members of the board, owns a property that becomes, and you become a landlord to Mohave County, and we lease that unit under the Housing Authority, which means we put tenants under our program in your housing, that is a conflict of interest, and that needs to be disclosed. So I know that we're looking at this conflict of interest policy on one instance, but I need to bring to your attention that there is a facet of this conflict of interest that relates to the county being a landlord, the members of the Board of Supervisors potentially being landlords to our housing authority, and that would present a conflict. I think that needs to be addressed as part of this because it will be inclusive of that as well.
May I, Mr. Johnson? Mr. Watson, may I?
Supervisor Moss?
I think that would be a conflict if
Yes.
you're making money. If I, as a board member, rented to your housing authority a house and you're paying me $1,000 a month or whatever it is, that's clearly a conflict, and I would have to disclose it, and I'd have to recuse myself from the vote.
Yes.
It doesn't mean that the rental can't occur.
That's true.
Because a conflict doesn't mean that there's no deal. It just means I have to say, I have a conflict, and I go down and sit down there for the duration of the discussion and the vote. That's all. The deal may still go through.
Yeah, and that's correct. I think we need to revisit this issue as a remote interest because, say for instance, other instances wherein I'm the executive director for the Housing Authority, I could not put my house, if I own properties, which I don't, for rent, they could not put those houses under the rental assistance program under Mohave County because I, as an executive director, also has a decision-making capacity for that as well. So I think we need to revisit this tenant-landlord thing because we forget that Mohave County is also running a housing authority which picks landlords for our tenant program. So I just want that to be included in the discussion for reconsideration of the policy.
May I, Mr. Watson?
So noted, Ms. Dransell. Thank you.
May I make a comment, Mr. Watson?
Supervisor Moss?
If you picked yourself as a landlord for the Mohave County Housing Authority, I would say, Susie, why?
That's true. We had instances in the past, and the main reason we passed the conflict of interest policy is that we had a board of supervisors who owned several rentals in the area, and we made sure that it becomes a conflict for that board member, to be able to lease that, or not just a board member, but I think a management person in Mohave County owning a lot of property in the area and was coming up for rental assistance under our program. So we had to pass that policy because it is a possible conflict, or there is an appearance of conflict of interest in those situations.
Thank you, Mr. Dransell.
Mr. Chairman, not to further muddy the waters, but
Mr. Exton?
in some instances, a conflict of interest may be prohibitive. It may say that you simply can't do it, and I think in the case of the Housing Authority, you can't do it. It's a separate law dealing with conflict of interest. The conflict of interest statutes we're addressing here is state law. It's set out in kind of a funny way because it lists all the things that are remote interests, and then it says anything else is a substantial interest. So the list of remote interest, I suspect, compiled by Mr. Asuna was the one out of the law. That doesn't mean you can't say we believe it's substantial and therefore you can't do it. But just to clarify the fact that those in all likelihood are items listed in the law as remote and permissible. So, and we'll deal with those issues as we revisit this thing.
Thank you, Mr. Exton.
Mr. Chairman, with your indulgence, I move that we table item 7 until our next regular meeting, and that we further direct staff as to the list of remote interests that were provided to us, if they would provide us their legal and factual basis for identifying those items as being a remote interest between now and the next meeting.
We have a motion
Second.
and a second to table this item till the next meeting. Any further discussion? There being none, those in favor signify by saying aye.
Aye.
Those opposed, motion carried. At this point, I'd like to entertain a motion for an executive session to talk about the Lincoln National information. Is that correct, Mr. Ekstrom?
Yes, to discuss about some collateral issues to item number 3 on the agenda.
I move that we go into executive session to discuss collateral items regarding item 3 to this agenda.
A second.
A motion and a second to go into executive session. Those in favor signify by saying aye.
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 Those opposed, motion carried. We'll try not to drop you, Supervisor Johnson.
I appreciate your concern. Being dropped.
How does that happen? Do they move him in there?
I don't know. Well, thank you very much, ladies and gentlemen of the audience, for waiting for us. We just got back from executive session, and at this point, we will adjourn this meeting.